Hi, everyone. Today, I'll be talking to you about the federal government's criminal law power in Canadian constitutional law. This power is rooted in Section 9127 of the Constitution, which states that the federal government controls the criminal law except the constitution of courts of criminal jurisdiction, but including the procedure in criminal matters. Under Section 9128, the feds get control of penitentiaries, which hold all prisoners serving sentences of 2 or more years. Section 9215, by contrast, gives to provincial jurisdiction the imposition of punishment by fine, penalty, or imprisonment for enforcing any law of the province made in relation to any matter coming within any of the classes of subjects enumerated in Section 92. Section 9214 gives provinces power over administration of justice within their borders. Section 926 gives the provinces control over jails, which hold prisoners serving sentences under 2 years. Provinces, predictably, are also given authority over provincial courts under 9224. The administration of justice in the province, including the constitution, maintenance, and organization of provincial courts, both of civil and criminal jurisdiction, and including procedure in civil matters in those courts. So that's the text. To figure out what it means in practice, let's move on to the case law. The modern 2-stage test for determining what constitutes a criminal law originates, for all intents and purposes, in the 1949 margarine reference. The statute being challenged would have banned the manufacture, importation, and sale of margarine derived from anything but milk or cream fat. No nutritional or health rationale was present or arguable. The law was meant to protect dairy farmers from competition for economic purposes. According to Justice Rand, a federal law is valid under the criminal law power when it serves a criminal law purpose and meets the formal requirement of being a prohibition backed by a penalty. A non-exhaustive list of valid criminal law purposes is given on page 50 of the opinion. Laws meant to preserve public peace, order, security, health, and/or morality are covered by 9127. These subjects are not pulled out of thin air, as Rand explains the principle that unites them on page 49. Ultimately, criminal laws are about safeguarding public interests. I quote, "A crime is an act which the law, with appropriate penal sanctions, forbids, but as prohibitions are not enacted in a vacuum, we can properly look for some evil or injurious or undesirable effect upon the public against which the law is directed. That effect may be in relation to social, economic, or political interests, and the legislature has had in mind to suppress the evil or to safeguard the interest threatened. Both intention and impact are to be considered in this analysis. See paragraph 49. As per the court, laws extending protection for a particular industry at the expense of another are not dedicated to the public interest, since defining them as such would practically subsume provincial control over property and civil rights under 9213. In the margarine reference, the impugned law exists to benefit one group of persons as against competitors in business, in which, in the absence of the legislation, the latter would be free to engage in the provinces. To forbid manufacture and sale for such an end is prima facie to deal directly with the civil rights of individuals in relation to particular trade within the provinces. In Dominion Stores Limited v. R. 1979, a provision requiring farmers to meet the federal definition of Canada Extra Fancy apples when selling within their own province using that label was similarly found to lack a valid criminal law purpose, according to a 5-4 majority. In Labatt Breweries of Canada Limited v. Attorney General of Canada 1980, the Supreme Court clarifies that regulations on food labeling and quality do not constitute criminal law unless they deal with food adulteration, food safety, or the misleading of consumers. It should also be noted that the prevention of individual self-harm constitutes a form of combat against public evil and is valid under the criminal law power. This was established in R. v. Malmo-Levine, where the Supreme Court upheld a prohibition on marijuana possession on the grounds that protection of vulnerable groups from self-inflicted harms was a valid public purpose. Overall, the federal criminal law power is pretty broad in terms of subject matter covered. The second stage of the margarine test, concerning the form of the legislation, also allows for significant wiggle room. R.J.R. MacDonald, 1995, provides useful guidance for both parts of the test. Here, the Tobacco Products Control Act was challenged by a cigarette company. The act banned promotion and advertising for tobacco products sold in Canada. Advertising of foreign tobacco products in imported publications was not subject to the ban. While the act's main provisions were struck down as free speech violations, the act was found intra vires parliament under the criminal law power. The dissent essentially says that conduct has to meet a minimum level of severity, i.e., a significant grave and serious risk as per paragraph 200, in order for a prohibition on it to qualify as criminal law. Since Parliament only criminalized advertising of tobacco products and not the act of smoking itself, they did not view it as a serious evil, especially since even that ban on advertising was incomplete. The majority did not buy this. The legislation being designed to protect public health clearly had a valid criminal law purpose. The fact that Parliament put certain carve-outs into the law doesn't mean they think smoking is okay. It merely indicates that Parliament was sensitive to practical concerns when figuring out how to fight the evil of tobacco products. Thus, we can infer that the presence of exceptions or exemptions does not render a law outside the scope of the criminal law power. See paragraphs 52 through 56. Let us now examine the test's requirement regarding a law's criminal form, which requires criminal laws to be a prohibition enforced by a penalty. Where a valid criminal law purpose is found, the court allows some wiggle room in terms of form. The Queen v. Zelensky 1978, for instance, upheld laws allowing orders of forfeiture of proceeds of crime, also confirming the constitutionality of federal statutes allowing compensation of victims to be ordered in criminal cases. Elaborate federal product safety specifications for cribs and cradles were upheld under the criminal law in R.V. Cosman's Furniture 1972. So we can safely say that while regulatory features may point away from a law being criminal, they are not necessarily dispositive of the issue when a valid criminal law purpose, such as the protection of infants, is present. Even broad grants of regulatory discretion can fall under the criminal law power, as in R.V. Hydro-Quebec 1997. The statute gave a minister immense regulatory authority over substances listed as toxic by the ministry, in cooperation with the advisory committee. Ministers can also bypass the committee using interim orders if immediate action is deemed necessary by them. Violating the regulations makes you subject to criminal penalties. According to the majority at SCC, this law meets both the purpose and form requirements of criminal law, though it is clearly flexible and regulatory in nature. Pollution is an evil, and the statute provides a remedy. There is a major public interest in the environment. Criminal law protects our fundamental values, and environmental stewardship is a Canadian value. Our next landmark case is the firearms reference. The facts are similar to Hydro-Quebec in many ways. The scheme was challenged on the grounds that it was too regulatory to be criminal, given its high complexity and the broad discretion it gave to the chief firearms officer. The provinces compared the federal gun control regime to the automotive and land title registry systems, which were constitutionally within the provincial domain. The Supreme Court did not find this analogy convincing, siding with the feds 9-0. They found that, integral as they were to the scheme's functioning, the law's regulatory aspects were secondary to its criminal law purpose. The Food and Drug Act and Environmental Protection Act are complex and discretion-based too, but still valid federal law. In the court's view, the Firearms Act's effect on property rights was minimal and incidental, a conclusion that would be hotly disputed by many gun owners. The gun registry is differentiated from the land and auto registries because its purpose is the preservation of public safety, rather than the property regulation rationale of the latter two. Personally, I find this characterization dubious. If automobiles weren't dangerous, I doubt they'd be regulated much at all by the provinces. Plus, the reasoning here seems to imply that the feds could establish a carbon copy of the provincial auto registry, and it would still be upheld as long as they did it for public safety instead of property regulation purposes. I'm going to quote the case. The argument that the federal gun control scheme is no different from the provincial regulation of motor vehicles ignores the fact that there are significant distinctions between the roles of guns and cars in Canadian society. Both firearms and automobiles can be used for socially approved purposes. Likewise, both may cause death and injury. Yet their primary uses are fundamentally different. Cars are used mainly as a means of transportation. Danger to the public is ordinarily unintended and incidental to that use. Guns, by contrast, pose a pressing safety risk in many, if not all, of their functions. This seems like a non sequitur to me, quite divorced from factual reality. The primary purpose of guns isn't to endanger the public, it's to defend oneself, participate in sport, and maintain the conquest of nature on one's property. Essentially, the court asks themselves a question about primary use and gives themselves an answer concerned with the danger inherent to the activity. I'm left wondering which one matters to them. Either way, the alleged difference here is not material in my eyes. The primary purposes of guns, shooting non-human entities and defending your person, pose no more danger to the general public than the purpose of cars, commuting. And if potential danger to the public is the concern, I don't think there's too much difference between guns and automobiles either. A van attack or car bomb is just as deadly as a mass shooting, and a girl who gets pulled into a stranger's van is in an equally bad position as one being held at gunpoint. I'd say a well-intentioned person with no driving experience in a car is just as dangerous as an untrained shooter with similarly pure intentions. And that equivalence still holds when experienced supervision is provided. But at the end of the day, the court is the final authority on the Constitution's meaning, and according to them, the Firearms Act is valid. Let's fast forward to the Assisted Human Reproduction Act. The underlying principles of the law are set out in Section 2. Basically, the scheme is meant to protect individual autonomy and well-being from exploitation. The text is on screen. Substantively, the AHRA contains some prohibited activities in Sections 5 through 9. Section 5 prohibitions include cloning, creating a vitro embryo for purposes other than creating a human, and creating hybrids/chimeras to transplant into a life form, including humans. Sections 6 and 7 pretty much prohibit commercial trade of embryos, cells, genes, and gametes. Payment for surrogacy is also banned. Section 8 says you can't make an embryo from someone's reproductive material without their consent. Section 9 says you can't extract gametes from minors. The AHRA also contains some controlled activities, set out in Sections 10 through 13. Controlled activities must be performed in accordance with the regulations and under a license. Such activities include manipulating reproductive matter to create embryos, combining human and non-human genomes, and if I remember correctly, compensating donors of genetic material and surrogate mothers. Sections 14 to 68 contain provisions detailing the Act's licensing schemes, penalties, regulations, and provincial equivalency agreements. The AHRA reference decision is a complicated one. The decision was 4 to 1, with Team McLaughlin upholding every provision, Team LaBelle blocking everything at issue except Sections 60 and 61, which were only saved to the extent that they were integral to constitutionally valid provisions, and Cromwell picking and choosing a diverse smattering of specific provisions to uphold. Let's dive into the reasons. First, McLaughlin. The chief found that the main purpose of the act is to prohibit/restrict immoral/dangerous actions. This is its dominant effect, too. She recognized that there were some impacts on the provincial sphere, but that's okay to her. Restricting immorality is solid criminal law territory, and nothing in the act forbids provinces from being stricter. The prohibitory sections clearly met this definition. Though the law is extensive, complex, and obscure, RJR MacDonald and Hydro-Quebec had already established that this does not render the law non-criminal. Regulations passed under its authority would only be upheld to the extent they further valid criminal law goals, of course. Team McLaughlin thought that the controlled activities section should be upheld too, as regulating, licensing, and monitoring the relevant activities is necessary to stop them from devolving into immorality. Regulations dictating morally irrelevant minutiae can simply be struck down, so the statute provision is okay. The rest of the act, in their view, was valid due to the ancillary powers doctrine, even though some provisions were not criminal law. After all, it only impinged on a small corner of the vast topography of provincial powers over health, paragraph 135. Since the intrusion on provincial powers was minor, the ancillary powers doctrine would test the law using the rational and functional connection standard, and the law would be upheld. Team LaBelle took the opposite view. stressing the need to define the pith and substance of the impugned provision as precisely as possible. The intent was not simply to prevent evils, but also to encourage certain human reproduction and research activities by establishing uniform standards across Canada, in accordance with the Baird Report, on which the law was based. The actual effect of the law was the regulation of medicine. Ultimately, they found that the law's pith and substance was the regulation of assisted human reproduction as a health service. The punchline of LaBelle's opinion is found in paragraph 250. First, from the standpoint of morality, no evil has been identified. Second, all activities related to assisted human reproduction are regulated, not just the specific ones that Parliament could theoretically have considered, but in fact did not consider reprehensible. They found that the presence of ethical questions did not mean that criminal law power is justified on the basis that there is an evil to be suppressed. Basically, all medicine involves ethical questions, especially as it emerges from new technologies. Overall, the impugned provisions fall squarely within the field of property/civil rights and hospital control. This constitutes serious federal overflow on provincial powers, dictating that we use the necessity test for our ancillary powers analysis. This standard is not met, so the impugned provisions must be condemned. The decisive vote in this case was from Justice Cromwell, who wrote an opinion for himself alone. The pith and substance of the act to him was the comprehensive regulation of assisted human reproduction. Cromwell agreed mostly with LaBelle, but would uphold sections 8, 9, and 12 under the criminal law power because they prohibited practices Parliament saw as evil. The other provisions were only valid insofar as they helped enforce those valid provisions. The most recent major formulation of the criminal law power at the SCC was the 2020 Genetic Non-Discrimination Act reference. Here, the proposed law says you can't make people take a gene test or reveal its results as a condition of contracting with someone. The Human Rights Act would be amended to stop employers from forcing genetic tests or the disclosure of results. Kara Katsanis provided the majority opinion in this case, joined by Abella and Martin. She found that the purpose of the law was to prevent and prohibit genetic discrimination. The effect of the law was that individuals get to control whether they take genetic tests, and if they do, whether to reveal the results. Even then, that info cannot be used without the consent of the person. She accordingly concluded that, in pith and substance, sections 1 to 7 of the Act protect individuals' control over their detailed personal information disclosed by genetic tests in the areas of contracting and the provision of goods and services in order to address fears that individuals' genetic test results would be used against them and to prevent discrimination based on that information. This falls within the criminal law power, as this is essentially an exercise in protecting Canada's fundamental values. Moldaver and Cote found that the law was meant to protect public health more than prevent genetic discrimination, but agreed that the law should still be upheld under the criminal law power. This case also reaffirms the absence of a seriousness of harm requirement. Parliament simply has to be addressing a reasoned apprehension of harm. The other 4 members of the court in dissent found that the pith and substance of the Act was to regulate the use of genetic tests in relation to employment and insurance contracts in the interests of public health, paragraph 154. They found that embodying or enforcing Canadian values is not enough to make a law criminal. Rather, it must be aimed at suppressing a specific public evil. They propose a 3-step test for the criminal law power. Step 1 is to ask whether it is related to a public purpose. Step 2 is to ask whether it is suppressing a well-defined threat. Step 3 is to ask whether the threat is real, that is to say, whether the perception of a threat has a concrete basis and the law is based on a reasoned apprehension of harm. Applying the test, these dissenters found that the Genetic Non-Discrimination Act would fail steps 2 and 3 because promoting public health is too vague of a goal to constitute the suppression of a well-defined threat. Accordingly, the dissent believed that the act would be ultra-virus and therefore invalid. So, that's it then. Criminal laws or provisions passed by the federal parliament will be upheld under the Canadian Constitution, at least at the validity stage of the analysis, and provincial laws with the similar pith and substance will usually be blocked. Under the margarine reference test, a criminal law is a law that serves a valid criminal law purpose, usually using a prohibition and a penalty. Laws that protect public interests or suppress evils can generally be said to serve criminal law purposes. and those protecting the interests enumerated in the margarine reference are especially likely to be upheld. Protecting members of vulnerable groups from self-harm, as in Malmo-Levine, may be a form of criminal law. The harm principle, in other words, is thankfully not a part of Canadian law. As we have seen in the firearms reference, Hydro-Quebec, and the AHRA reference, complex and discretion-laden regulatory systems can often be justified under the criminal law power, though statutes supposedly lose criminal lawishness points for this. The harm being prevented does not have to hit even a minimal degree of severity for the criminal law power to be engaged, as per the genetic discrimination reference in RJR McDonald.